Your Ladyship, Madam CJ, there is something that is likely to be lost as my two learned friends are fighting. And it is so important, it could compromise really the fairness of the hearing which you have endeavored with so much effort to craft a way forward. It is this. 8 petitions were filed against my client within the 7 days cast in stone in the Constitution. It is the first time in this republic that 8 are filed. In 2013, there were 2. But because of ingenuity of this side of the court, we now can file very many, all intended for the same purpose. That aside, I burnt midnight oil, filed my response within time. Then comes the group of 4 commissioners. On 26th August, they have filed a response to the petition. They are filing this under the pretext they are respondents. They file a response. It is not a response. It is a new petition. There are new claims, new grievances, new grounds for nullification of my client's electoral victory.
Senior Counsel.
Yes.
I think a ruling was delivered on their participation as respondents.
If you could just allow me 1 minute.
What we are addressing is whether they should be represented by lawyers of IMBC.
I was dealing with the response that they have filed. And that is the point that I think my learned friend, Githu Muigai, was alluding to. Will that response still be on record, or are they limited to the affidavits that they had filed and which have been allowed? Because if the response is also part of the record, a response filed or a new petition filed outside time, I do not know whether I need to respond to it and whether it will be admitted by the court, notwithstanding the strictures in Article 140. I hope my...
We've got a new Senior Counsel. What we are dealing with is the application of whether we should allow counsel to represent the 4 commissioners. As you can see, the 2 factions are insisting they are representing IMBC.
And in the mix of it is that response that has been filed by learned counsel Paul Muite's team.
We
maybe
volunteer to consider that application.
Please.
Which was, I think, filed out of time. So
yes, that is
night.
Is filed out of time.
So we'll consider it and come back with a ruling.
Correct.
Yes.
That's number 1. Number 2, again, something which may be lost out. When I look around me, my colleagues each representing a party. And as you said, some could be secondary petitions. They each have, under the guideline you give, 4 lawyers each. Very carefully, I did.
And it's only the main parties who have 4 lawyers.
All the petitioners are main parties.
Okay.
All the petitioners are main parties. Say, for example, petition number 1, they have my learned friends, 4 of them. And the same goes for each petition. I don't know why the noise is being generated. I can see a battery of governor. Is each 2-2? Or, huh?
Mr. Ngatia, the other petitioners have 2, not 4.
Oh, very well.
So you really have no reason to complain.
Thank you so much, my lord. Nonetheless, actually, that makes my work much easier. Each has 2, there are 8, 16, or against nullification of 1 person. And then that 1 person, you limit him to 4 lawyers. I appreciate, I'll be the first one to say we are living in difficult times. But surely it will be very difficult for me, and I say this in all fairness, to be able to master a defense against all the 18 lawyers when all we have is a team of 4. Let me say the last thing, Madam Chief Justice, because your fairness is legendary. The total time given my learned friends, all the 8 of them, is 8 hours. I have been allowed 3 hours. I would have requested you, Madam CJ, if there's any way you could, allow me at least half the time that my opponents have, so that I could at least be able to master a defense in relation to petition number 5, the primary, and the proxy ones, the 6 of them. That is all.